It's my privilege to introduce our next speaker, Ian Coleman. However, before I do that, can I take this opportunity of also acknowledging the presence of some other people that I think their presence is special for us. One is Malcolm Kerr, who was a member of this House for about 25 years or so, wasn't it, Malcolm? Where is Malcolm? Well, he was here anyway. I'd also like to acknowledge the presence of Nicola Nye, the daughter of Professor Nye, and a former judge Nye, that Dr. Bernasconi referred to, and also Professor Suzanne Howarth from Canberra University. You'll hear from them a bit later on. There were a number of practitioners that have asked me to apologise on their behalf that they couldn't be here because they had made commitments to other cases in court, and they didn't want to incur the wrath of the judge by asking for a late start. And I can see that Justice, I think Swithers agrees that they should not have asked for a late start. Can I also acknowledge all of the members of my staff that have helped with this? There was Chantel Bainey and Farnaz Magami, and also my daughter Afifi. And in particular, and coincidentally, an intern also from the Netherlands, Britt Veldhuis, who has been with us now. She came here to spend 6 months getting some legal experience. She's been here about 4 weeks. And all she's had experience in is event management. So, so thank you very much for that. But Ian Coleman, SC, and I'm proud to say he's a fellow practitioner, but also a very close friend, who was admitted as a lawyer in 1974 and called to the New South Wales Bar in 1975 and was appointed senior counsel in 2013. He was appointed to the Trial Division of the Family Court of Australia in 1991, a Judge Advocate of the Australian Defence Force in 1992. He's a Commissioner of the Australian Law Reform Commission since 1993 and appointed to the Appeal Division of the Family Court in 1999. He was a Judge in the Family Court of Australia from 2009 until 2013. He is currently an Adjunct Professor at the Western Sydney University School of Law. Would you please join me in welcoming Ian Coleman?
Honourable members, Your Honours, professors, ladies and gentlemen, I hope that hasn't left anybody out. Thank you for inviting me to speak today. I would first acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I would also acknowledge the cultural heritages which are represented in the room today and acknowledge the contribution which the diverse cultures of our nation have contributed to our strength as a nation. Simple administrative matter. Rick, how long am I meant to bore these good folk for?
We'll let you know.
Is it about 20 minutes?
About 20 minutes.
All right. Rick, in his usual kind way, has basically, as far as I can see, given me about 18 months of academic study to cover in about 20 minutes. So to say that it will be superficial would be to be complimentary. I should say that the quality of my knowledge of and presentation with respect to private international law should not in any way reflect upon the late Honourable Professor Peter Nye, who had the invidious task of trying to teach me and about 50 others about private international law at Sydney University Law School about 130 years ago. I also had the immense privilege of being a colleague of Professor Nye when each of us were in another phase of our lives on this earth, and he was as probably all truly scary bright people, as I like to call them, are, he was modesty personified, and he was simply a wonderfully warm and intelligent and wonderful man. I may have misunderstood what I was meant to do, which is fairly typical, but I had understood that the focus of what I was to speak about was more in relation to the impact of private international law on family law in Australia. As I hope will emerge, there is a degree of, or an extent to which the principles of private international law as embodied in the domestic laws of Australia, in the Family Law Act and in the regulations to the Family Law Act, which embody the Hague Convention on the civil aspects of international child abduction, work together. There is, however, a very large extent to which the impact of international conventions has yet to find expression in the domestic laws of Australia with respect to family law. And it was interesting to hear Dr. Bernasconi refer to mediated agreements. I'll speak about that briefly, but quite independently of Dr. Christoph's comments, and based on recent practical experience, it seems to me that in an era where prenuptial agreements, however they're expressed, binding financial agreements in the family law jurisprudence in this country, prenuptial agreements as they are more commonly known throughout Europe and the United States, are increasingly going to, and their recognition and enforcement, I think, are increasingly going to assume significance in this country, as indeed are mediated agreements. I was engaged in a case recently involving the application of the Hague Convention by the central authority on instructions from a state of the United States. The basis of the assertion that the removal of a child from the United States to Australia was in breach of rights of custody under the Convention was reliance upon a mediated private agreement. That involved, in turn, the intricacies of the agreement itself, which was, not surprisingly in the circumstances of that case, quite a complex document, the interpretation of which in itself was not without complexity. What I hope to do is analogous probably to flying around the world on a clear day at 40,000 feet in a jumbo jet and noticing bits and pieces of stuff somewhere down there below. It will be spectacularly brief. I wanted to refer first of all to the issue of recognition of overseas decrees and orders by Australian courts. Broadly speaking, recognition of overseas decrees and orders falls into two categories. The first relates to decrees of divorce, separation, annulment, pronounced in overseas or by overseas courts. Their recognition in this country is codified under the Family Law Act, and the codification largely reflects the common law rules of private international law, both in terms of recognition and the refusal of recognition. The matter of most obvious significance is that the relevant section, Section 104 of the Family Law Act, if I may refer to that as the FLA, I will. It is limited to decrees of dissolution, annulment of marriage, or legal separation. It does not purport to extend to orders with respect to what I'll broadly refer to as custody, which can be taken as including all the various aspects that custody implies or entails. Maintenance. When I speak of maintenance, I do so in the limited sense of spousal maintenance, because child maintenance is to some extent, which we won't go into today because we wouldn't do anything else if we did. Child maintenance, and what is more commonly now child support, is to a considerable extent covered by international agreements which find expression in the domestic laws of Australia. And finally, and as I hope will be seen most significantly, property settlement orders are not expressly provided for in section 104 of the Act. What that means, broadly speaking, is that provided a decree which is within the ambit of the section doesn't fall foul of the common law rules of private international law and thus become disentitled to recognition, those decrees will be recognised and given effect to in Australia. One consequence of recognition that is sometimes not understood, and with respect, unsurprisingly is that so, because it rarely arises in practice, is the removal of the restraint on remarriage by a party to an overseas decree, which is registered, which is recognised in accordance with Australian law. Some decrees of overseas courts do, in effect, give with one hand and take with the other, in the sense that a decree of dissolution is granted, but there may be, under the laws of that country, an inability to remarry as a consequence of the decree. That decree, if it's recognised in Australia, would not have that effect. It's expressly provided by section 104(9) of the legislation. It would, I would submit, be fairly readily avoided in reliance upon the principles, the common law principles of private international law. In essence, and again this is summarising to a spectacularly reckless degree probably, but in essence, if a decree has been pronounced in an overseas court which is on its face regular and in accordance with the laws of the forum, it will be recognised by an Australian court unless the decree was obtained in circumstances which involved a denial of natural justice, in which case an Australian court will not recognise that decree, or recognition would be manifestly contrary to public policy. These are statutory provisions. The authorities here and in the UK have made clear that natural justice is likely to be broadly interpreted, but if, notwithstanding that natural justice according to our law was not afforded by the overseas court, but was nevertheless pursuant to the laws of the overseas court, natural justice or procedural fairness, however one expresses it, then avoiding recognition becomes more problematic. Generally speaking, the courts do not have difficulty in being satisfied whether procedural fairness was or was not afforded by the overseas court. The authorities, the English authorities, particularly in the 70s, suggest that the gravity of the consequences of recognition may influence a court's finding in any given case. And two decisions, Chowdhury in 1972 in the UK and Qureshi in 1972, show how quite different outcomes resulted in cases where a talak pronounced in England with respect to parties who were formerly domiciled in but were physically resident in the UK, which was lawful according to the laws of Pakistan, with quite different financial consequences for the parties, were treated very differently. And where the consequences of recognition were adverse, the court found its way clear not to recognise on public policy grounds. Where they were not, the court found its way clear not to avoid in reliance upon public policy grounds. It's probably a good thing that courts do this, because otherwise we at the bar would have a pretty lean time of things. A decree obtained by fraud would not be recognised. The older cases distinguish between fraud enlivening jurisdiction and fraud obtained in relation to the obtaining of relief. It's analogous to jurisdictional error under Australian law.